the starting point of what I'm talking about is, of course, legal, because I'm an educated lawyer, and the problem that we have to face simply is who is going to be held responsible for the death in this pandemic. We have already more than 100,000 people in Germany, which is more than 1% of the population, and I'm sure that this is going to go on. And the other point is, I mentioned already, I'm not very fond of fashionable topics, at least not in the field of law, but nevertheless, this time I have already written 2 articles about COVID-19. The first one is more or less something that we in German would call ironic, even sarcastic, and that is how to battle a pandemic with the use of a foreign language that nobody understands. I mean the English one. And that is something very striking in Japan and also in Germany. And when I wrote this article, that was in early 2020, I did not know yet that the German television ARD, as well as the German television ZDF, would be awarded the famous prize Sprachpancher des Jahres for using the same English words that the Japanese use for broadcasting these problems. We should not do that. The other article is much more serious. It is dealing with how we can make the people who are working in the health environment work more, because we have to avoid infections at the weekend as well. This is the a book for a friend of mine who happened to be a judge on the German High Court of labor matters. But let me start with tackling some of the problems. The problems that we have is the treatment of not infected persons. We have to have them tested. Then if we, of course, by force is necessary, that's always the legal point here, then we have to get them isolated before the announcement of the test result in order to make sure that they are not spreading the virus. And finally, of course, we have to talk about lockdowns if the whole situation is getting out of hand, and it got out of hand in a couple of countries, including Germany. Then we have, of course, to talk about the treatment of infected persons. We have to isolate them. We have to force them to disclose their contact persons to make sure that we can test them. We have to give them some kind of medical treatment. I mean, we could just isolate them and let them die, but the legal system provides otherwise. So we have to treat them to some kind of medical treatment. And then we have the big problem with persons without any symptoms, so that they even themselves sometimes do not know that they are infected. And then finally, the problem, how should we deal with people who are supposed to have recovered? And finally, let me talk a little bit about pharmaceuticals, and especially the vaccines in the legal world. For us lawyers, it is most difficult to get through to non-infected persons. We are talking about Nichtstörer. In the German law, I have translated this into non-disturber. And they are, of course, not subject or should not be subject to any legal restrictions. But what we do, of course, to find out who is affected by the virus or not, is we order and execute the so-called PCR tests. This is, of course, already an intrusion into the scope of the basic rights, according to the German constitution, because they have to come to some place to do this test. Obviously, meanwhile, it is also possible to do it privately at home, but then we have the problem of whether the result is recognized by the authorities. The intrusion is quite limited because, fortunately, the test does not interfere with the right to life and to health. There is usually not even a health problem involved. Only that the persons have to come to a certain place where the test is affected. And to find out whether this is constitutional or not, we are on a way that other countries did not take so far. We have an interpretation in Germany of our basic rights that other countries don't have. Usually, all the countries on this globe stick with the idea that the basic rights are only affected if the state, by some kind of active doing, is making an intrusion in the scope of these rights. But our constitutional court that was only set up after the Second World War, they developed very fast a different function of basic rights. Namely, they created a duty for the state to protect the basic rights of people whose rights are infringed by a third person. And to apply this idea on our pandemic, the people who are infringing on the rights of other people are the infected people. So we have to protect the non-affected people from social intercourse with the infected people. It's a duty of the state. And it was developed in cases that you, I think, all know. First, it was abortion because, well, the mother wanted to abort an unborn baby, but that would, of course, infringe the right to life of the baby. And therefore, the state had to protect the life of the baby against the rights of freedoms of the mother. Still highly controversial topic. The other topic that became quite famous in Germany is the refusal of the Jehovah Witnesses, a religious group, to permit the giving of blood to their children. And of course, that might be a cause for their death. Therefore, the state again put itself as a protector of the rights of this a sick child, of the Jehovah Witness believers, and gave the medical doctors the right for a blood infusion to the child. And we have this problem almost on a daily basis. Just imagine that you, as using your car, would like to take a certain street in a given city, but you can't because the demonstration is going on. There you have the collision between the right of the person who wants to use his car to drive through a certain street, and you have the colliding right of participation in a demonstration that is using the same street. So we always end up in a collision of basic rights, and this collision we have to solve somehow. And the court in Germany, the Constitutional Court, created something that we in Germany call Übermaßverbot, so a prohibition of access. And we have to ask whether what we would like to do to protect the rights of the affected people is appropriate. First step, if it is necessary, and most difficult to answer, is it proportional? So some people in Europe also call this the proportionality principle. And according to this principles, the German Constitutional Court on November 30th delivered a very good decision and declared all measures that were taken by the last cabinet of Angela Merkel not to be in violation of the Constitution. The problems lie elsewhere, as we have seen by the talk of Frau Heissig already. We have huge capacity problems, even for this simple PCR tests. And these capacity problems, well, they can be personnel, financial. As far as products are concerned, for tests, you need certain instruments, and also for spaces. So legally, the situation is quite clear. We can order and execute tests. Then the next problem is, do we have to isolate the people who have been tested in the time between the test and the announcement of the test result? And again, very clear, yes. We don't do it, but we could. We don't do it because we have this capacity problems again. Then the highly discussed lockdown. Of course, it's a strong intrusion into the scope of our basic rights. And therefore, we have to look very close at the point necessity. Is a lockdown really necessary? And Japan is an interesting example in this process of thinking, because Japan so far has not ordered a lockdown. Japanese state is very much concentrated on something that we call Zweckveranlasser in the German law. It's not very easy to translate into the English language, but it's basically the organizer of events and get-togethers as an addressee of state orders. So if you close down the universities, if you close down the schools, if you do not execute any events, then it should work. And it worked in Japan. And I think that my Japanese colleagues are quite happy with the result, that they did not have to order a lockdown. Yes, in fact, they even did not have to order something. They could stick with recommendations and still had most of the population following. This is something that is in Western legal systems often cited as a special feature of the Japanese legal system. You don't have to order, you just submit recommendations and the people will follow you. In cases where they don't, then of course the order has to come. And in Japan, you have to pay a penalty, and your name will be published, which seems to be a penalty enough to avoid following the recommendation. Yeah, finally, we have, of course, to deal with the infected persons. That is easier for us lawyers because they are legally disturbers. We call it Störer. So it is easier for us to isolate them completely. But again, we have this huge capacity problem. And we can also force them to disclose the names of people they have been in contact with. That, again, is not so easy in Japan because many Japanese instantly think that they do not want to be held responsible for infecting people around them and would rather not submit the names. This kind of thinking might also occur in Germany, but legally, again, there is no problem. We can order the disclosure of contact people. One of the big problems is here, the medical treatment. First of all, we don't really know, or at least our colleagues from the medical department don't really know how to treat. At least not with pharmaceuticals. The Japanese were talking about a cocktail of different pharmaceuticals that is supposed to work. It's not my discipline, so I do not know anything about it. The problem is a different one. Due to capacity reasons, we could not take care of all infected people. And there were three different consequences. Highly infected people could maybe get a bed in a hospital. For others, the government was only able to reserve rooms in hotels that they could not leave. But the worst alternative was taken very often, and that was go home. So although you are infected, you go to your own place where, if time and personnel allows, a doctor would look after you. But we had the most death in this third alternative. There is a third function of the German basic rights, and it is again difficult to translate in the English language. We call it Teilhaberechte, and I translate it here into right to participation. And that basically means that everybody of us, according to the German constitution, can execute his rights, and to do so, the government is responsible for creating an environment in which the executions of the basic rights is possible. And that was not the case. So we are probably in infringement with the German constitution at this point. The Constitutional Court developed this Teilhaberechte, this right to participation, strongly in another case, and this case was the kindergarten for people who are both employed. So for parents who are both employed, and you all know German population is shrinking, and therefore the government was very interested in keeping both parents at their workplace, but the children are also needed for the stabilization of the economy, and therefore they said, well, we bring them to a kindergarten, and we have to create an environment in which every child can have a right to join a kindergarten. And they created even a public subjective right to have a kindergarten place. And this same idea is behind the medical treatment environment. I think that we violate this principle. Then, yeah, this is a very difficult question to answer. Infected person without the symptoms of the disease, the only thing we can order is daily tests, followed by immediate isolation. But again, we are facing a capacity problem that we did not solve so far. And then we have still to face the other problem of supposedly recovered former infected persons. They also should be subject to daily antibody tests and isolation if necessary, but this also did not happen because of capacity problems. As far as pharmaceuticals are concerned, of course, the most important question is, can we force non-infected people to accept vaccines? And again, we have the same collision of basic rights. And it is more or less clear that we are going in the direction of putting a duty to get vaccination into law. I'm personally very surprised that this question is discussed at all, because we have the duty to get vaccinated in a number of diseases in Germany without anybody crying and saying anything. Of course, we have to provide for exceptions from vaccination for those people who have certain diseases. But these few people are probably acceptable because of a phenomenon which is called the herd immunity. And I guess I do not have to explain that. But again, we have capacity problems, not only in terms of the available number of doctors who are willing and able to give shots. And also, we don't have the staff, right? We don't have the necessary vaccines in the necessary number. The final problem is the infected persons. Again, we lawyers are highly dependent on what the colleagues from the medical faculty tell us about available pharmaceuticals for infected persons. And obviously, we are not doing too well in this respect, but that's something that Heisig Sensei probably can answer much better than I can. As a result, all executed intrusions in the scope of basic right in Germany were not in violation of the German constitution. I already cited, oh, this is a misprint, I'm sorry, it must be read November 30th. There was this decision. I also believe that the same intrusions would not be unconstitutional in Japan, but Japan did not test or was not in a position to really test the limits of their own constitution. As I told you, some different legal approaches, as we had them in Germany, they were not discussed in Japan and did not have to be discussed in Japan. because they were fully compensated by the actual facts in Japan. We have massive capacity problems in both states. This should not happen in states that belong to the strongest economies of the globe. But because it happened, I believe we are at least in violation of the participation right that is guaranteed in the German constitution. And we will see what happens if there will be a case against the government for not being able to create the necessary environment to treat all people equally. Finally, what we should both work on in Japan and in Germany, because it's needed in both constitutions, is provisions for the pandemic emergency. We have provisions in Germany for military problems. We also have something for catastrophes in place, but we don't have anything in place for pandemics. The Japanese don't have anything in place, and therefore we should definitely think about it. Thank you for your patience.